Hello.
We're all here.
Okay, so the meeting has not started yet. Okay, that's good. How are you, Mariam?
I'm good, Arsha.
Hey guys, welcome. We'll give it another minute and we'll go ahead and get started. Stand by. Hey Otto, if you can hear me, just give me a thumbs up. Awesome. Sometimes I've gotten a couple of minutes into these things only to find out that I'm muted or something, so I just want to make sure. All right, so I'm going to go ahead and get started. If you want to chime in, you'll have to unmute yourself. But there's quite a bit of content to cover today, so let's go ahead and just jump in. So today's boot camp is on the leasing process and lots of different things about the leasing process. And so for some of us, we've done a ton of these and kind of know all the ins and outs. For others of us, we only do leases occasionally. And so every time we're faced with a lease, we feel like we're kind of rusty and don't know exactly how to go about doing a lease. So today's agenda is not just going to be about that. We're going to take a look at the current eviction moratorium. We're going to take a look at the leasing process from the perspective of the tenant and the landlord. Okay, so if you're representing the tenant or if you are taking a lease listing. Okay, so let's jump in and talk about the current moratorium that is in place. And this is generated by the CDC, okay, so the Centers for Disease Control. And the reason why the moratorium came out was because a couple of reasons. One is that if people were being evicted from their homes, it was either going to cause a situation where they were going to be homeless or they were going to be forced to move in with others, thereby creating a greater likelihood that COVID was going to be spread within that household. The second reason was because people were losing their jobs through no fault of their own. Okay, so this was enacted by the CDC. The language or the screens that I have in here for this week states that it ends on the 31st of January. That has actually been extended to March 31st, which is supposed to give Congress enough time to figure out exactly what to do overall about the issue. But so what I did was, I went right to the CDC's website for all this information. So I'm a firm believer in just go right to the source versus someone just writing about the subject. So this comes right from the CDC's website. So what does this order do? So this order temporarily halts residential evictions of covered persons. And I'm going to review what a covered person is in a moment, for non-payment of rent during September 4 2020 through January, or I'm sorry, in this case, March 31st of 2021. This means that a landlord, owner of a residential property, or other persons with legal right to pursue an eviction or a possessory action, in other words, going to take back their home that they own that's being rented out, cannot evict for non-payment of rent any covered person from any residential property in the US, state, or US territory where the order applies. We explain where the order applies and who is covered later in the document. Okay, so what do they mean by eviction? So eviction means any action by the landlord, owner, or a residential property or other person with a legal right to pursue eviction or possessory action, i.e. an apartment complex management company or a property management company, to remove or cause to remove of a covered person from a residential property. All right. As indicated in the order, court should not take into account, should take into account the order's instruction not to evict a covered person from rental properties where the order is applied. The order is not intended to terminate or suspend the operations of any state or local court, nor is it intended to prevent the landlords from starting eviction proceedings, provided that the actual eviction of a covered person for non-payment of rent does not take place during the period of the order. Okay, so if the actual process of the eviction is to take place between last September and March 31st, that's fine. Anything before that, where eviction proceedings had started, it does not apply. Okay, so, and that is separate from how late they are in the rent. It just applies to when the proceeding is going to start. So let's review what their definition of a covered person is. So who does this apply to? So a covered person is any tenant, lessee, or resident of a residential property who provides to their landlord, the owner of the residential property, or other person with a legal right to pursue eviction or possessory action, a declaration, and that's a key word, under penalty of perjury that. So this is a document, and I'm going to pop up a copy of this in a second, but this is kind of what the spirit of the document is going to say. The individual has used best efforts to obtain all available government assistance for rent or housing. Okay, so if they are, if they can apply for a grant or subsidy or some kind of financial assistance, they have to prove that they've exhausted all those possibilities. 2, the individual either expects to earn no more than $99,000 in annual income for calendar year 2020, 2021, or no more than $198,000 if filing jointly. 2, was not required to report any income in 2019. 3, receive an economic impact payment stimulus check pursuant to section 2201 of the CARES Act. Okay, number 3, the individual is unable to pay the full rent or make a full housing payment due to substantial loss of household income, loss of compensable hours of work or wages, a layoff, or extraordinary out-of-pocket medical expenses. Okay, the individual is using best efforts to make timely partial payments that are as close to the full payment as the individual circumstances may permit, taking into account other non-discretionary expenses, and eviction would likely render the individual homeless or force the individual to move into and live in close quarters in a new congregate or shared living setting because the individual has no other available housing options. So the declaration, I'll go back to that slide in a second, but the declaration looks like this. Okay, and then it basically says, I certify under penalty of perjury pursuant to 28 USC 1746, so on and so on. And then those bullets that I have kind of truncated there, it's what I just went through. Okay, so they are signing this under penalty of perjury that one or more of all those things have occurred, okay, to qualify. But how does someone use this protection? A tenant, lessee, or resident of a residential property must provide a completed and signed copy of that declaration as described above, to their landlord, owner of the residential property where they live, or other person who has a right to evict them from where they live. The declaration may be signed and transmitted either electronically or by hard copy. Each adult listed on the lease, rental agreement, or housing contract should complete the declaration. In certain circumstances, such as individuals filing a joint tax return, it may be appropriate for one member of the residence to provide an executed declaration on behalf of other adult residents party to the lease, rental agreement, or housing contract at issue. So I have posted the link to all this stuff, including the declaration, on our webpage. Okay, so if you are ever in a situation where you need to access this information, it is right there. Okay, so here are some questions that the website also proposed. If I am a covered person, do I still owe rent to my landlord? Yes. So covered people still owe rent to their landlords. The order halts residential evictions only temporarily. Covered persons still must fulfill their obligation to pay rent and follow all other terms of their lease and rules of the place where they live. Covered persons must use best efforts to make timely partial payments that are as close to full payment as their individual circumstances permit. And we've read a lot of this before. Okay, so this is a delay, not an absolution of payment of rent. Okay, in fact, the declaration, I think, even says landlord has the right to collect all or part of the back owed rent by a certain date. Okay, can I still be evicted for reasons other than not paying full rent? Yes, you may still be evicted for reasons other than not paying full rent or making a full housing payment. The order does not prevent you from being evicted for engaging in criminal activity, threatening the health or safety of other residents, damaging or posing an immediate and significant risk of damage to property, violating any applicable building code, health ordinance, or similar regulation relating to health and safety. So non-payment is really the only reason that falls under this mandate. There are still lots of other things within that lease that the tenant can be evicted for. But in terms of non-payment, it's going to be tough. Do landlords have to make their tenants aware of the CDC order of declaration? No. They are not required to make their tenants aware of the order and declaration, but landlords must otherwise comply with all requirements of the order. Okay, now Texas has a plan called the Eviction Diversion Program, which if you think of it in terms of a residential sale, this is let's get together and work it out type of deal. Okay, so it's kind of like arbitration. It's, look, I as the tenant know I can't pay rent. Can I get together with a landlord to work something out? And this link is on our web page as well. So there's lots of different ways they can, they can stave off eviction if they just kind of get together with a landlord. Okay, the reality is that justices of the peace are who you file an eviction with, and they really aren't hearing cases for non-payment because of all that's going on for like 30 to 60 days. So it's significantly delayed. And there, as you can imagine, there's a lot of lack of clarity in these situations. There are people that are genuinely in need. There are people that are on the fence. There are people that want to take advantage and aren't in need, but they're going to try and get away with whatever they want to get away with. So as you can imagine, because they're not meeting in person, a lot of these cases are backed up. And then, any litigation is going to be messy. And so you add on top of that the delay of these cases, and it can go on for a little bit longer. And so many landlords are stuck. A lot of people that got into this home investing deal 10, 12 years ago when there were a lot of foreclosures, and now they're landlords, and they may own one or 101 different assets. A lot of them are finding themselves kind of in a bit of a bind, especially those that are only own, 2 or 3 or 4 assets, because the mortgage company is, they still want their mortgage. So if the tenant isn't paying, then that's an issue. Okay. So are there any questions about what we just went over? I don't know it probably as much as I should, but I can certainly try and answer questions if you have them. No? Okay. So I thought it would be helpful to go through the eviction process just in general. So pre-pandemic, before what I just read went into effect, because there's a lot of apprehension about eviction, because it's a legal proceeding. It involves courts and filing things and, the confrontation of having to kick somebody out. And so whether you represent a tenant or a landlord or it's your own investment property, there is huge trepidation about the eviction process. So I'm going to go through it. I have been through it as a landlord, owner, investor. So I'm going to kind of give you my 2 cents as we go through this process. So the timeline is that once they are delinquent in rent, and I believe in Texas it's 3 days, the landlord has to give the tenant 3 days to bring their financial commitment current or move out. Okay, so it is a letter of demand, and it has to be proven that it's been delivered. So it is usually posted on their door and mailed, certified mail, signature required, to be able to prove that they have received it. Because you don't want someone, pushing back and say, well, what are you talking about? I never received anything. And so you are giving them their first chance to pay up or move out, basically. Okay. So we're 3 days now. If they don't, the landlord files an eviction with the county clerk's office, and the justice of the peace is the legal entity that is going to hear the case. Once you do that, there is a 10-day waiting period for a judge to hear it. The mere filing of this stays on someone's record for 7 years. Okay, so I had one of the situations where the tenant and her family was creating a disturbance in the home, in the neighborhood. They were delinquent in rent. Okay, so it was perfect storm. And so I made her aware of what I just said. And I said, look, we can do this the easy way, and I'm just going to ask you to move out. And here's the document that is my formal request to do that. If I don't, or if you don't, this is what's going to happen. You're not going to be able to rent another place ever. Usually an eviction is a deal breaker. She needed a home too. It wasn't, an apartment might do it, but this was going to create huge headaches. She moved out. And so no one really ever knew the conflict that went on. So just be mindful that even if the process doesn't go any further than the filing, that filing stays on that person's record for 7 years. Okay, so let's say the 10-day waiting period elapses, and now we're at 13 days, right? Hearing is scheduled. And it usually pre-pandemic was in the next 7 days. It wasn't long. And so like 50% of the time, the tenant won't show up. So let me just go back and say this. In Texas, if it's a residential sale, we all know that the contract is in favor of a buyer. In the property management world, the laws are more in favor of the landlord and not the tenant. That doesn't mean that the tenant doesn't have very distinct rights. And so, in other words, as an example, landlord can't shut off utilities or lock people out because of non-payment of rent, or really any reason. So that's an extreme example, but otherwise it does not take much to evict someone. Okay, so let's move on. So if the eviction stands, and so if they don't show up, it's an automatic ruling that it's an eviction. Okay, so if the tenant, defendant in this case, does not show up, they rule in favor of the landlord. Okay, many of them don't show up. Now, if they do show up and they're deemed to be, you need to move out, you're being evicted, the tenant has 5 days to appeal. If they appeal, there's an 8-day waiting period for the judge to hear that. That rarely happens. The tenant is just embarrassed for the most part. They know that they have to move. They just want to sometimes wait to the last possible minute and just hope that it works itself out. That is most of the cases. If the eviction stands after the appeal, tenant needs to move out within 24 hours. Okay, so now we're at about 2 weeks, 2 to 3 weeks. That's if they didn't appeal. If they refuse to move, the landlord then files for a writ of possession, it's called. And that is forcible removal of that tenant and their belongings. And that falls on the shoulders of the constable. So the constable will go to the tenant's door and give them 24 hours notice that they need to vacate or they're going to be forcibly removed. If they still don't move, then that's when the constable physically removes all their belongings to the curb and takes possession of the home. So if you are ever driving around a residential neighborhood and you pass the constable coming the other way, they are likely delivering that notice. So this is the stuff that makes the newscasts, right? It has to get pretty desperate to get to this point. And so it does. And I can imagine that in what's going on today with people losing their jobs and such, that it's probably happening more than it was a year and a half ago. But that's the last step, and that's it. If they don't physically, willfully move, that's what happens. Okay, so all in, you are talking 3 weeks, maybe 4. The only way it's going to take longer, and I'm talking pre-pandemic, is if the landlord drags their feet on doing this. So, and I'm going to go into this in a moment when I review representing tenants on the landlord side. Nice guys finish last in this business. You've got to set precedent for what the rules are. So this kind of, hoping that they'll pay, or, they always pay me, it's just always a little late. That is a recipe for disaster, because something will happen where they really can't pay you. And their defense to the judge is going to be, well, in the past, they let me pay on the 15th. Why the change? So it's just important to abide by the rules from the outset. Okay. Any questions about the eviction process? All right, y'all ready to file an eviction?
Hey, Brad.
Yeah.
Fast question. So after the constable comes and their physical belongings are removed, does a landlord have any obligation regarding those belongings, or does the constable take over, legal responsibility for those belongings that are removed out of the property?
No one does, and I've researched this before. In that usually the landlord goes in and obviously changes the locks for security reasons. In that instance, no one in that equation, except for the tenant, cares what happens to those belongings. At issue is they're squatting in a home that they're not paying for. And so all the legal aspects of that process, as I just explained, have been exercised. So what is in the house is inconsequential. It's about regaining control of the house. So no, No one has any responsibility for those belongings.
Thank you.
Yep. Okay, so let's talk about tenant representation. So what is the process? Okay, so this is not unlike representing a buyer, right? So if you get a client that wants to help you or have you help them find a lease, you're doing the same stuff you normally would, send out auto emails. You can work with apartment complexes as well. Just make sure that if it is an apartment complex, be sure to register yourself with the management company and ask if they pay a referral fee. They won't typically call it a commission, but most of them do. It's like anything. You just have to make sure you prove that you're the one that brought that tenant to the equation. So if they want to go the apartment complex route, you still have to go with them. I mean, I know there's a leasing agent that kind of takes over and shows them the place, but that's still your client. So you need to go and still show those properties with them. Okay. Try and know everything about the tenant before showing homes. So such as credit history, rental history, employment, and just ask directly, look, is there anything that may come up on a background check that would keep you from getting this home? And the reason is that, each of these applications is going to be 35, 45, 50 bucks a pop. And so if they have a felony or if they've been evicted, or, you can probably exclude low credit score because typically that's what you're going to run into. But all the deal breakers typically, right, are evictions and felonies. So if that is the case, I'd want to know that up front. And their only recourse in that case is probably an apartment complex. Not always, but you might be, if that's the case, you might be running around trying to get a home that they'll never be able to get. All right. So, leases can be easy money if they are looking within 5 miles from where you live. So I used to do this as well, but I never used to drive out more than 5-6 miles from where I live, just because the leasing market is always very competitive, and it's speed to market, right? And so I never thought it was worth it to drive more than 5 miles out from where I lived. So, but if that's the case, I mean, it's an easy few $100. All right, so let's talk about the application process and money handling. So many homes that are managed professionally will have a website that the applicant can go and fill out an application and get the credit check. That's the ideal situation. And this will usually be in the actual listing. So if you are ever guessing as to how to fill out the application, just look at the bottom. The other spot is the document section. Okay, sometimes they'll tell you there. Otherwise, before you fill out a TAR application, which can be labor intensive, I would reach out to the agent and just say, what form of application are you taking? Okay, and so maybe at that point they'll send you a link or say, no, it's just the standard TAR form. Okay, and then all applications in this space, they all have a part where the tenant agrees to a background check. Okay, so they have to consent to that. All right, so avoid accepting or handling any money yourself. That is really between the applicant and the landlord, or the applicant and background checking company. So, certainly don't ever take cash. I don't like this part of this process. I think that the more streamlined this can be, the better. So, please avoid taking a check from an applicant if it's not made out to the landlord. I mean, if it's made out to the owner landlord, great, just deliver it to them. But if you do that, there has to be some process where your applicant's getting a receipt. Okay, so this is kind of a, think about a sale. All that money, earnest money and option fee, there's a paper trail there, right? And it begins and ends with you and the title company. But in the leasing world, it's a little more gray. So again, whatever you can do to not handle money would be awesome. Okay, so this is the TAR application. And I just kind of screenshotted a part of it that I wanted to highlight. And that is just the acknowledgement that they're agreeing to a background check. So authorization, applicant authorizes landlord and landlord's agent at any time before, during, or after tenancy to obtain a copy of the applicant's credit report, obtain a criminal background check related to applicant and any occupant on the lease, and verify any rental or employment history, or verify any other information related to this application with persons knowledgeable of such information. Okay, so at the bottom of this, what you don't see is their acknowledgement and signature of this. Okay, so this kind of gives the landlord the green light to go and run these reports. Okay, then it says notice of landlord's right to continue to show the property. So unless landlord and applicant enter into a separate written agreement otherwise, the property remains on the market until a lease is signed by all parties. Okay, so just because they're applying doesn't mean that they're not showing it to other people. All right, and then lastly, acknowledgements and representation. Signing this application indicates that applicant has had the opportunity to review landlord's tenant selection criteria, which is available upon request. Now, I'm going to go into this a lot more when I review landlord representation. But if you want to save yourself some headache, ask for this. If they don't have one, then that could be an issue. Doesn't mean it's a deal breaker, but it makes the transaction potentially more risky, and I'll tell you why. So the tenant criteria form is usually a one-pager created by the landlord that says, these are all of my criteria for renting this dwelling. And it could be things like, can't have any pets, credit score has to be 640 or higher, have to have held a job for 2 years or more, no eviction, no felony, or no criminal record of any kind. Could be anything within the boundaries of the fair housing laws. Let me just be clear. However, they are the things that they will be able to point to beyond the normal rejection reason, which is credit score, as to why that applicant is not going to be accepted. But if you don't know that ahead of time, you're not going to know. And if you're representing a tenant, and this is their 5th application, and now they're in it for $250, they're going to get very, very angry as to why they continue to be denied, and there's no real reason. So better to be upfront and transparent. And so if it's not in the document section of the listing, ask for it. Okay. All right. So let's say the application is accepted. You initiate the agreement between brokers. Okay. The listing agent does not do this. If they have in the past, they're just being nice. Okay. So this is your only way of getting paid. So you initiate the agreement between brokers, fill out what you're supposed to get paid, and that's going to be on the MLS listing under BAC, right? And send it to the other agent to be countersigned. Okay, then the landlord creates the lease. So if you're representing the tenant, you do not create the lease. The landlord creates the lease for your renter to review and sign. Okay, deposits will be due usually when they sign it. So whatever financial obligation there is, first month's rent, security deposit, whatever, it'll be crystal clear as to when that's due. It's usually at signing. Your renter should fill out the residential lease inventory and condition form, TXR-2006, before signing the lease, and you should schedule a walkthrough to complete this process. So I know that on this form, they give you several days to fill this out because, you know, how would you know if every outlet worked and so on? But please have your tenant walk through the property and take pictures and note what the condition of the property was when they moved in. I kind of think of when you rent a car and they take you out with the little carbon copy diagram and say, okay, it's your responsibility to tell me where all the dings and dents are so you're not charged for it when you turn it back in. Same principle, okay? Most landlords are honorable and, you know, get it, but some aren't, and you want to have a written record of what the condition of the property was. Okay, there is no formal closing, all right? So tenant moves in when the lease states they do. So there's a lot of back and forth. It's the landlord creates the lease, you present it to your client signs it, you give it back to the landlord, and let's say there's 5 days in between the time that happens and move in, and that's it. There is no ceremonial, here's a bottle of champagne, congratulations on your new home. It's not like that. You know, they move in whenever they move in. All right, so once the lease is signed, tenant and landlord have that relationship. So tenant should know where to send rent, how to make repairs, all that. So similar to representing a buyer, your only job is to unite a willing tenant with a willing landlord. That's it. So once that lease is signed, that relationship transitions into one between the landlord and the tenant themselves. All right, and then send the agreement between brokers and our W-9 to the listing agent to get paid. At the bottom of the agreement between brokers, it says this, by the way. It says send this form and our W-9 to the listing agent so they can get paid. Our W-9 is on our website under contracts. And I believe it even says W-9, use this for leases or referrals. Okay, so it's on there. All right, any questions about tenant representation? Okay. The lease listing process. So this is again similar to listing a home for sale. The payout is going to be small. And so any place that you can do a reasonable job for free, I would do it. One is taking pictures. I mean, if you have a nice camera or your phone has a nice camera, I might just do that. You know, when the payout is only $300, $400, it's hard to, you know, write a check for $100 to a photographer to take photos. Now, if it's a $3,500 lease, I would pay someone to take photos. But most of the time you can get away with just doing it on your phone. All right, prepare the landlord, owner, and yourself for a flood of calls and questions. So the off phone calls that I get on my cell phone, because my number is on a lot of the company information, are about leases. So I mean, like I said, I mean, it's high demand out there for leases, and so just know it is a lot of legwork, a lot of, is your property still available? And you're going to get a lot of calls, and not many people follow through with the application process. So it's a lot of work, just setting expectations. Okay. Have these documents in the listing: explanation of how to apply and the tenant criteria form. Okay. This staves off risk. So we have a tenant criteria form on our website, and it is just a placeholder. It has the usual 10 or 12 things that a tenant might be denied the application for: credit score, various things that I mentioned earlier, an eviction, so on. It is in Word format so that you can change it. So, you know, again, the credit score I never really worried about, because typically that's what you're going to get. I think you could argue that if they could buy a home, they'd buy a home, but they can't, so they're renting one. And so what I concern myself with, if you want to kind of advise your client, is eviction, criminal background / felony, length of employment, amount of money that they make. And so you're going to want to ask for paycheck stubs, and their ability to pay their bills. And so their ability to be consistent with bill payment is going to be somewhat reflected in their credit score, but not always. So, and I think the rule of thumb is if the rent payment is more than 30% of their take home, that's going to be a problem financially. Doesn't matter how good of a money manager they are, that's probably going to be a problem. So, and I hate to say this, but minor, like misdemeanor offenses after a while didn't necessarily bother me unless they were due to violence. An eviction was always a deal breaker for me. And if they didn't make enough, was a deal breaker for me. But here's the deal. This tenant criteria form has to be done in collaboration with your client. You can't dictate what the reasons are for a decline. But I think that between the two of you, in my list, you'll land on what it is, okay? If your client appears to be in a hurry just to fill the house, man, please do your level best to slow them down, because it only ends poorly. I'll give you a real quick story. I have a realtor that has a client that doesn't live around here, and he's been very loyal to this person, buying and selling real estate, some owner occupied, some investment, and he just wanted to get the rental property filled. And along comes this person who, through conversation, they knew she was very upfront. They knew that she wasn't going to be there very long. He didn't make a whole lot of money, but one sob story later, one written letter later, they let her in. And fast forward to now, this is about a year ago. She wasn't supposed to be there for past 6 months. So now she is still there and hasn't paid rent in 6 months, and the landlord doesn't know what to do. So that is a result of just wanting anybody in there for the sake of just having anybody in there. So when you think about how many people apply for a rental property, you can only take one. And so the ability to be able to have this tenant criteria form accessible and completely public, and to be able to say, this is why you were turned down, is critical. It's a necessity. Okay, so I know I spent a lot of time on the tenant criteria form, but it's very, very important. You can't just willy-nilly say, well, I just didn't get a good feeling about that guy. That is a lawsuit waiting to happen. Okay, so the next process is determine the commission. Average is about 80% of 1 month's rent. And then you're going to split that with the person that brings the tenant. If you can get 1 month's rent or more, great. Apartment complexes, a lot of times, are giving you 1 month's rent as a referral, just FYI. It's not bad. All right, and then, a client, landlord, owner is more apt to get a qualified tenant if they use a realtor, and it's because of this process. It's when they, again, want to get someone in there because they don't want to do another mortgage payment, sometimes is not the right way to go. So a realtor assigns a process to this and makes sure that they're getting the right tenant. Okay, so let's talk about the application process, because this is another kind of fork in the road that prevents, I think, a lot of agents from taking lease listings, because they have no idea what the application process is and who kind of oversees that. So who does the credit check and the background check? Well, luckily, Zip Forms and our Texas Association has made it very easy lately in the past month by providing companies and partners that do this. And so in the spirit of keeping this as hands-off as possible, this is actually a good thing. So I'm going to go to these applications. So this is the one in zip forms. And did I time out? When you create a transaction, let me go back to transactions. This won't pop up until you create a transaction. So I created a test lease. Okay. So when you click in the transaction for your client, you're going to see Marketplace pop up. Okay. So again, this is you representing the landlord. If you click on Marketplace, here are all the partners that Zip Forms works with. Well, if you scroll down, you'll see one called Rent Spree. And if you click on Rent Spree, this is a credit reporting background check application process. So let me just go ahead and get started. If it's not on the MLS, you can put the property address in, and I'm not going to go any further. However, I will just tell you that once you get to the end, it will generate a link that you can then send out to the applicant. And from there, the applicant can fill out an application, they can consent to a background check, and they pay the landlord directly. Okay, so Rent Spree is one, and then Smart Move is the one from Texas Realtors. And if you want to go to, just go to texasrealestate.com and just in the search box type Smart Move, and you'll see what you're seeing here. And below is an explanation of how theirs works. It's extremely similar. It's all link driven. You don't handle any money. The report goes directly to the landlord, which is what you want. You don't want to get these reports. It is not your decision as to take what client. It's free to sign up. So is Rent Spree, by the way. And they're pretty inexpensive. Okay, 30, 40 bucks. So know which one you're going to use, because the price of this is going to dictate how much you're going to put in the MLS listing for the application fee. So if this is a $35 charge, you're going to want to put in $35. Okay, I wouldn't add any more. You're asking for trouble. So just beware that you don't have to worry about who does this and what the process is. It's all electronic. Okay. All right. All right, so the application should go directly to the landlord, not you. Take no money for this process. Applicant should be able to click a link and just pay directly. Okay, so the rejection process, the most critical part in landlord representation. Most of TREC's complaints are about leasing and property management, period. Okay, and it's because if you have 50 applications and you can only accept one, and the other 49, this is their 10th application, they're going to start to get defensive and think that they're being discriminated against in some way. Okay, that is the main theme of TREC complaints in property management and leasing. Whether that's turns out to be true or not, doesn't matter. It doesn't prevent anyone from filing a complaint. That is why the tenant criteria form is so critical. Okay, so a landlord does not have to, by law, provide a reason for rejection unless it's because it's something found in their credit report. So let me just stop there for a quick second. If you represent a landlord, I would always write why they were rejected. Now, and that's going to fall right back to the tenant criteria form. Now, the application, the TAR application says, if I can't verify this information, I being the landlord, if it's incomplete, if it's false, then that is grounds for rejection. So if I asked for a previous landlord recommendation or reference and you didn't put it down, that's incomplete. Okay. If they provide incomplete information, it's just going to get worse from there, right? But I'm just trying to point out what the outs are without getting into trouble. Okay, so if you represent a landlord, I would always tell them why they were rejected. Now, let's say it's for the most easiest one, which is they can't financially rent this home. Either their credit report, their credit score is not the minimum for whatever you put in the tenant criteria form, or their credit report is a history of their ability to make payments. And so if they are in arrears with multiple companies, well, that's a reason for rejection. However, because of the Fair Credit Reporting Act and all of the legislation that occurred about 10 or 13 years ago, you have to tell them that. Okay, so if it's for a financial reason, you have to provide an adverse action notice and credit score disclosure, which is TXR form 2212. And it's simple. You know, it just says, this is the reason for your rejection. This is what we found in the credit report. And this, as you can see, by matching it up to the tenant criteria form, is not in alignment. Okay. The most important reason for using this is because there's a clause in there that tells the applicant that they have a right to that credit report. And most don't take you up on that, but it has to be made available, because I have had people think that their credit score is this and it's really far below that, or there is something on there that shouldn't be. And it doesn't mean they're going to get that home, but it does make them aware that there is something amiss on that report. They have legal right to get that report, and the company providing it will get that to them. Okay, so you will need to know what number and what contact information for either Smart Move or Rent Spree or whatever other company you're going to use is the one they contact to get it. Okay, you can't just send out TXR 2212 and not have that on there. You have to give them a means to get that report. All right, and then be sure all rejections are solely based on something in the tenant criteria form. That's why it's important that that document is thorough and very specific. Okay, as an example, if their credit report suggests that they are they had a late payment on a credit card 5 years ago, that may or may not be a big deal, but please be very specific in the criteria form that says credit report should reflect no late payments that are older than or are newer than 5 years. Okay, it's got to be that specific. So, and again, that should be done in collaboration with you and the landlord. Okay, so let's say the application is accepted. You turn the status to active contingent or pending. You prepare the lease, okay, with the input from the landlord based on his or her policies. So you are just kind of the scribe. So if any of you are familiar with the association's version of a lease, assuming the landlord does not have one, there's a lot of stuff on there. Do you have pets? Is there a pet deposit? What's the late fee? What's considered late? Who takes care of the pool if there is one? Who takes care of lawn? Who takes care of irrigation? What if the HOA comes after you for something? Who does that? There is a lot of crossing of T's and dotting of I's that need to be done in that document. So make sure that you're reviewing what the landlord's policies are before you present that back to the client, or I'm sorry, the tenant's agent. You're not making up these policies, right? So the landlord is. You're just putting them down. So once you do that, obviously I'd have the landlord review it, make sure it captures what he or she wants. Okay, you can collect the deposit, or landlord can handle directly, avoid property management duties, just in general. Okay, I would insist on a walkthrough and a signed copy of the property condition form. Take pictures as necessary. So this is on behalf of the landlord now. So he or she has a vested interest on how that property looks just as much as the tenant. And so is that crack in the tile, was that done before that person moved in or not? I mean, if you've got multiple properties, it's hard to keep track. Okay, commission payment and closing it out. So landlord pays broker directly for entire commission. So your client writes a check out to White Rock Realty for the entire commission before anything is split with anybody. I then pay you what you're entitled to, and I then pay the tenant's broker, right? So not agent, that's wrong. So I'm going to pay that agent's broker, and what he or she decides to do with that with regards to splits is up to them. But whatever that BAC is what I'm paying. Right, close it out in the MLS, give the other agent the credit for bringing the tenant. Okay, and so that is kind of it on the lease listing side. Any questions? No, I know we covered a lot. So if you enter into a lease relationship, be it tenant representation or landlord, chances are you'll still have questions about this. So please don't hesitate to reach out to me. We want to get this right, especially if you're doing a listing, because that's going to involve turning people away. Okay. All right. Sent out a couple of emails this morning. The new version of the consumer protection notice hits February 1st. The new versions of the 1 to 4, where you can now drop off option fee and earnest money to the title company, is mid-February, mandatory on April 1, I believe. And then if you do not have a drip campaign set up in email, that is the easiest way to stay top of mind. So I sent out this morning all of the marketing material that I have provided for you. It primarily centers around holidays and things to celebrate. You can always take something from Backagent and send it out too. But if you need help setting up a MailChimp account or doing this, let me know. But I think that's just bare minimum what a realtor should have. Even if you're doing this part-time, you want to make sure that there's always something out there that's going to cause someone to reach out to you. So, so that was it. Anybody have anything else for today? We went the whole hour. All right. Well, I appreciate your attendance, guys. I really do. You're awesome. And you guys have a great rest of the week. And if you want to come back to this, I'll have this posted on our website. You guys take care.
Thank you.